so much for joining, and we have a really special treat. This is a very special thing. It is the first Capstone speaker series ever. So we're going to try to do a lot more of these things. And, you know, students write these fantastic 12-page white papers, and we're going to try to do more focus on them. It's a change we've made in terms of academic enrichment and making it ready. One of the things that human resources professionals are asked to do is to write white papers, and so we have incorporated that possibility into our work. And Valerie is one of the first, but we've had, to be entirely fair, we've had other folks who are from the cohorts and from our alumni, including Bob Oberstein, who's with us tonight. Hello, Bob. And other folks, you know, do papers for us on equal pay and other things and mentorship. But this is very special because this paper comes from our Capstone experience. And so I want to introduce Valerie Nance, who, despite her youthful appearance, has decades of human resources experience working for, which I didn't know this, one of my favorite places in the world. Do you want to know what it is? The Carnegie Museum of Pittsburgh, which is a beautiful, if you ever get to go to Pittsburgh, it is a beautiful, wonderful, I thought every city had dinosaur bones in the museum. And it turns out the Carnegie Museums are a luxury, in part because of folks like Valerie who worked there. So various kinds of people manager capacities she's worked at, including, you know, now serving as a human resources, the head of human resources for the Penn Hills Charter School of Entrepreneurship in the city of Pittsburgh, which is, as you guys know, we've had a lot of conversations. I'm sure she would never say this because Valerie is never beaten by a challenge. But oftentimes in schools, like in hospitals, you have a lot of population of many women who are having babies. And so there's a lot to navigate in a school. Plus, you know,
4 right now.
4. I didn't mean to invoke that, right? But those of you who work in hospitals or schools, maternity leave and these kind of flex things are a very big challenge. And so she knows, with what she speaks of about gender and the future, because of the populations that she works with and the work she does. One of our most, I hope I don't embarrass you when I say this, one of our most enthusiastic, excellent students. We're very blessed, and we're blessed to have all of you, and you know, I feel a very proud, you know, when Valerie volunteered, I was very proud because it was an easy thing to say yes to. So without further ado, I've given you opportunity to share your screen if you need to, and I will be quiet.
Yeah. Thank you for that lovely introduction. I really appreciate it. And it's an honor to represent Tulane. I'm so grateful to this program. And can everybody see my first slide? Hold up, give me thumbs up. Yep, thank you very much. So I want to take you back to a little moment that gave birth to this capstone research, so to speak. I was waiting for a friend in a bar one night. It's a bar restaurant. And she was very, very late. She's also an HR professional, and she had an employee relations emergency at the end of the day, and was very, very late for our meeting. So I'm sitting in this restaurant, and I order myself a cocktail, and I get some buffalo dip, and I'm ready to, you know, just settle in until she can make it. And I was waiting for over an hour, but I was really happy because I had 2 law review articles in my purse, and I sat there with my highlighter and I read work by 2 of the people I'm going to talk about today, Susan Sturm and Catherine Ross Dunham. And that moment was so inspiring, and what I was reading was so inspiring that when it came time to select a capstone topic, I knew what I wanted to do, and that is this topic tonight. So we are going to hold up the mirror to invisible gender discrimination. And our objectives for this evening are, first off, to go back in time. We're going to talk a little bit about history. We're going to talk about the evolving conversation on sex-based discrimination. We're going to talk about the success or failure of bias-based discrimination cases. We're going to talk a little bit about judicial bias and where that plays a role in all of this. And we're going to talk about a possible proactive preventative approach to bias elimination. And then we're going to have some concluding thoughts. So starting off with some background and some history. There was a stark differentiation between women's work and men's work leading up to passing of Title VII of the Civil Rights Act. Sex, as defined during that time frame, as we know, was binary, assigned at birth. You had women, you had men, and clearly defined roles for both. And so I want to take you to 1964. It's January, it's the second session of the 88th United States Congress. And the House of Representatives is going through their hearings. Proposed civil rights legislation hearings begin. And Howard Smith, Virginia Democrat, he's been in office for 33 years. He brings forth the proposition of adding sex as a protected class under Title VII to prevent, quote, discrimination against another minority group, the women, end quote. So there's a lot of debate about why this gentleman, Howard Smith, brought forth this idea of adding sex as a protected class under Title VII. And some legal scholars have, thought that this was a poison pill because Howard Smith was known to be a segregationist. He was very opposed to civil rights protections for Black and African Americans. And you can watch film of him talking about why desegregation is a bad idea for the United States. He's a very slow-talking Southern gentleman with his cigar talking about the evils of desegregation or why it would be a bad idea for America. And the idea is that adding sex as a protected class was such a ludicrous, ridiculous concept that Howard Smith believed that his colleagues in Congress would think this is so funny and so ridiculous that it would kill the bill entirely and thereby eliminate the problem, so to speak, quote unquote, problem of civil rights for Black and African Americans. Other legal scholars have said, now wait a minute, maybe it's not so simple, because Howard Smith had a record of supporting women's rights for decades. He'd been a career politician in office for 33 years. He had long supported the Equal Rights Amendment, providing civil rights protections for women. And so there is a theory that this was the result of years of strategy on the part of the National Women's Party and an agreement between Catherine St. George and Martha Griffiths, who you see here photographed, to leverage Smith's years of experience and his power in Congress and his power to influence others in Congress. Ultimately, do we know what motivated Howard Smith? We don't. We can't get inside his brain. But ultimately, Title VII of the Civil Rights did pass with protections in place with sex as a protected class. And I just want to point out here, we've got one Republican and two Democrats. Look at that bipartisan effort, something that we struggle with today in American politics. So gender discrimination before and after Title VII. Title VII was passed at a time when there was a stark division, as I said, between men's work and women's work. Bias against women in the workplace was overt and explicit. There was deliberate exclusion based on gender. And before Title VII, the cost to a man who discriminated against a woman in the workplace was minimal. That kind of behavior was normalized. Women struggled for job security and retention. And as the culture adjusted to the workplace protections Title VII afforded, the idea of sex was tested in early cases. So you've all probably heard about Phillips versus Martin Marietta Corporation, in which the US Supreme Court held that an employer's refusal to consider hiring women with preschool-aged children for employment violated the act when men with preschool-aged children were not treated the same. So while Title VII was successful in checking overt intentional discrimination, facially neutral practices that had an equally discriminatory impact proved to be more elusive. So let's talk about that a little bit more. Nearly 40 years after the passing of Title VII of the Civil Rights Act, Susan Sturm, a Columbia University professor, introduced the legal theory of second-generation discrimination in her 2001 article. She argued that the judiciary's traditional rule-based approach had been successful in reducing overt discrimination, what she labeled as first-generation discrimination, but it was less effective in addressing subtle, complicated, and often unintentional forms of workplace inequity. And this becomes a self-perpetuating cycle of discriminatory policies that on their face are neutral, but they have a disparate impact on the minority, while the majority group doesn't have any reason to believe that they're doing anything wrong. They don't have a reason to believe that they are violating workplace access necessarily. So what does this look like? It looks like stereotyping. It looks like mentorships, social connections, the diversity of boards, other informal norms that exclude women and result in discriminatory impact. So from an employee life cycle lens, again, what does this look like? Bias perception can impact ideas about an employee's capability, performance, and skill set over many stages of the employment process. So think about committee assignments. Who gets invited to lunch? Who gets invited to happy after work? Who gets invited to meetings? Who's asked to present? Who gets asked to attend professional development or conferences or networking opportunities? Who's on the executive team? And so by the time a critical employment decision is made, like a promotion decision or a salary change, the die is often cast. And the decision maker is often unaware of how much those previous social connections, evaluations, work assignments, committee assignments, etc., have been based on bias. So Catherine Ross Dunham took Susan Sturm's theory to another level in her 2017 article, Third Generation Discrimination, the Ripple Effects of Gender Bias in the Workplace. She argues that even safe work environments harbor implicit gender bias. Her article explores the role of implicit bias in the court system, arguing that gender-based bias against female litigants creates a third generation of gender discrimination that hinders the success of workplace implicit bias cases, which further perpetuates subtle forms of gender discrimination. So let's explore her theory. And let's talk about when second generation discrimination goes to court or doesn't, as the case may be. A very heavily analyzed case is Walmart versus Dukes, a fascinating case. This deals with the issue of class commonality. It is a class action lawsuit of 1.5 million female Walmart employees who joined Betty Dukes in a lawsuit against Walmart stores. Betty Dukes was a Walmart employee. She filed a sex discrimination suit against Walmart in 2000, claiming that she had been denied job training in order to receive a promotion. After she achieved the position of customer service manager, her path to further advancement was blocked, she claimed, and she was actually demoted. She was a greeter at the time that she filed her lawsuit. And the claims in the lawsuit were that Walmart's facially neutral promotion decisions favored men and paid women less than men in comparable positions. The decision makers were predominantly male, so women were repeatedly overlooked for promotions. So manly men are promoting manly men. Store culture perpetuated stereotypes about women's lack of leadership skills. Each individual plaintiff in the Dukes case had a relatively small claim and limited resources to file separate lawsuits against Walmart. And so class action seemed to be the ideal choice for this group of women. But ultimately, the Supreme Court determined that based on evidence, the plaintiffs had not shown that there were questions of law or fact common to the class, which is a requirement under the Federal Rules of Civil Procedure. And on June 20th, 2011, so this was a long period of time, the Supreme Court ruled unanimously in Walmart's favor. There's a wonderful article analyzing this case called "You Can't Get There From Here: Implications of the Walmart versus Dukes Decision for Addressing Second-Generation Discrimination." And according to the authors, the rejection of class action commonality dealt a major blow to structural or second-generation gender discrimination cases. They argue that the primary policy issue in class actions is balancing the access of individuals to courts and the need for efficiency in the court system with the need to protect large businesses from frivolous class action suits. In their view, the Walmart versus Dukes decision made equal rights second to the protection of business interests and had a chilling effect on future plaintiffs from bringing forth claims of structural discrimination. Another case that Catherine Ross Dunham analyzed in her article was the Powell versus Kleiner Perkins case. And this case deals with stereotypes in the workplace. How do we define womanhood in the workplace? How do we define the appropriate woman in the workplace, the acceptable woman in the workplace? Ellen Powell filed a claim for Title VII gender-based employment discrimination against her employer, venture capital firm Kleiner Perkins, alleging that stereotyping and implicit bias against female employees led to critiques of her work performance. So some examples of this: when she was short with colleagues and subordinates, she was criticized for being too masculine. When she didn't assert herself, she was labeled as weak and feminine. When she brought forth a complaint of harassment, she was a troublemaker. She argued that men were promoted ahead of women, women's ideas were dismissed, and that after ending a romantic relationship with a colleague, so she dated a colleague, slutty, slutty, slut, you know, here we are with the stereotypes about sexuality within the workplace. She was excluded from meetings and emails. The jury returned a final verdict in favor of Kleiner Perkins on all claims on March 27th of 2015. And Catherine Ross Dunham theorizes that if members of a jury believe the following stereotypes, that successful women are pushy and difficult to work with, and that a female employee is more likely to have seduced male colleagues than male colleagues are likely to have harassed women in the workplace, then jurors are likely to believe that a female plaintiff was a poor performer and to disbelieve her claims. I also read a study that involved women in academia, and I think that this is applicable to the workplace as a whole, not just academia. But it further supports the argument that regulatory and justice systems perpetuate the problem of sex discrimination. Subtle forms of implicit bias are nuanced, and interactions are experienced differently by different genders, and within the same gender, experienced differently by people of different race, ethnicity, sexual orientation, etc. So it's difficult to trace a pattern of direct evidence, especially when using rules developed in response to those overt, obvious forms of discrimination that we talked about earlier, that first generation of discrimination. So often cases settle before trial. they're dismissed, they're appealed. Employment discrimination plaintiffs win a lower portion of cases brought to hearing or trial and are more likely to have their cases appealed by defendants. The chilling effect is real. I really thought when I first read those articles by Susan Sturm and Catherine Ross Dunham that I would find so much. I thought I would find so many second generation discrimination cases, and I really didn't. And I believe that that's the result of this chilling effect that we talk about here. I did notice that post-Bostock, the Supreme Court decision in which LGBTQ status was included under under Title VII, which is wonderful. We see a lot of cases dealing with what would be defined first generation discrimination against LGBTQ workers. But again, I didn't find much on second generation discrimination. So does this mean that we have moved past implicit bias? Do we get to pat ourselves on the back and say, good job, America, we did it. We beat the bias problem. Men and women are completely equal now. Nope. So 2019, Deloitte's 2019 State of Inclusion Research Report. This was a marketplace survey of 3,000 full-time United States professionals working for companies with 1,000 employees or more. This was conducted between April 18th and May 3rd of 2019. So 39% of respondents experienced workplace bias at least one time per month. 83% of respondents categorized bias they experienced and or witnessed as indirect or microaggressions. 68% of respondents state that bias has a negative impact on their workplace productivity. Implicit bias is a problem, but what avenues are available to employees seeking to self-advocate? Many workers don't have the financial resources to pursue legal action against employers whose practices and policies appear neutral, but nevertheless have discriminatory impact. And if legal precedent shows that the only successful outcomes are awarded to litigants who were the victim of first-generation discrimination, then workers experiencing structural discrimination may not understand that what they're experiencing is worth pursuing under Title VII. Successful litigants have a difficult job to do. They have to establish a prima facie case under Title VII and also demonstrate that structural discrimination flows from implicit bias against female employees. The fact that most structural discrimination cases settle out of court or don't reach trial may be a form of bias itself, perpetuating silence on the part of victims. And so the problem silently persists. And as we can see with the following statistics from the United Nations Gender Social Norms Index report, this was published very recently, June of 2023. 9 out of 10 people worldwide hold fundamental bias against women. Worldwide, 50% of people believe that men make better political leaders than women. Over 40% of people worldwide believe that men are better business leaders than women, and women represent less than 1/3 of management positions worldwide. And the American workplace is a microcosm of a worldwide problem. As a whole, women are not valued and women are underrepresented in the spaces where decisions are made. So I say this tongue-in-cheek, blame the judges, because I think we do need to think about the judiciary and the role that it plays. What influences judicial outcomes? How does the judge's perspective on gender inform their decision-making? Catherine Ross Dunham and Christopher Leupold attempted to address these questions in a 2020 article, Third Generation Discrimination, an empirical analysis of judicial decision-making in gender discrimination litigation. And what they did is they analyzed judges appointed by Bush, Clinton, Bush, and Obama. Of course, this was not inclusive of Trump and Biden appointed judges because of the timing. Their results were somewhat inconclusive. They couldn't really pinpoint bias based on which presidential administration appointed the judges. The biggest finding, it appears, was that the older judges, regardless of gender, harbor the most bias. And while I believe that this analysis and data gathering is important, by asking these questions, I do believe that we're arriving too late at the problem. Or if we wait to place the problem in the hands of the courts and the judiciary, we're arriving too late at the problem. We trust our courts to understand subtle forms of discrimination and exclusion that may not be understood by the culture as a whole. And as a culture, we're unaccustomed to holding up the mirror on our own biases. And here I think it's useful to turn to psychology and the social sciences for possible solutions. So we're going to talk a little bit about something called restorative practices, which started in the 1970s in somebody mute. I'm hearing some voices. Everybody can...
That's the patriarchy trying to silence you, Valerie. Your message of freedom is having waves, and it's the patriarchy trying to silence you.
It sounds like a child.
Yeah. They'll use whatever tool.
All right, so this is something that started in the 1970s in the criminal justice system and rose to prominence in the Australian education system in the 90s. Spread to the United States in more recent years, including my school where I work. I'm the HR director at Penn Hill's Charter School of Entrepreneurship, through the International Institute for Restorative Practices. The idea is that society benefits from communal activity. Think education, work, trade, entertainment, sports, the arts, volunteerism, etc. But people living together have conflict, right? Laws and leaders are supposed to protect groups of people and to maintain order, but incivility, misconduct, and bullying are pervasive. Schools see themselves as an epicenter for change. So when we talk about cultural responsiveness, what is it? Well, in a school setting, culturally responsive teaching incorporates students' cultural identities and lived experiences into the classroom as tools for effective instruction. So how do we apply that to the workplace, right? So when we look at this slide, let's take out the word school community and just say community, okay? I want you all to think about how we can incorporate this within the communities in which we live. Let's try to imagine a culturally responsive workplace where workers feel safe bringing their whole identities and lived experiences into the workplace in order to work together effectively. So this next slide shows images of restorative circles within a prison setting and within a school setting. You may be thinking, what could be more different, a prison and a school? What happens in a prison setting is that restorative justice brings victims, families, communities impacted by violence or crime in conversation with the accused. Okay. A fantastic example of this is there's a podcast called Ear Hustle. Can't recommend it enough. It's out of San Quentin Prison. And season 2, episode 13, the episode is titled Dirty Water, features a sex trafficking survivor and restorative justice activist in conversation with a man convicted of sex trafficking and pimping. It's one of the most powerful things I've ever heard. Now, in a classroom setting, what might this look like? So maybe Nadia pinches Zion on the playground. When I was a kid, Nadia would have gone to the principal's office, and if it was before I was in 3rd grade, she would have gotten paddled, possibly. Very punitive approach. Nadia's the problem. Nadia needs to be punished. In a restorative setting, there would be a community circle, okay? Zion, the child who was pinched, would have an opportunity to share with Nadia how this impacted him. Nadia would be able to have an opportunity to share why she pinched Zion, what was going on. Maybe Zion was teasing Nadia. Maybe Nadia was hungry. She didn't have an opportunity to eat breakfast that morning and she was hangry. But maybe Nadia is typically pretty aggressive. And so the other children within the community are impacted by her aggression on the playground. And so we come to understand that this is not one child's problem that needs to be punished and fix it. It's a community issue. And we as a community need to take a problem-solving approach. A restorative approach couples high levels of nurturing and support with high levels of expectation and accountability. So we can see how this would be applicable in a school. How do we apply this to the workplace and adult parts of our culture where humans interact? We support one another. We hold one another accountable. And what are we restoring? We restore those who have been harmed by the wrong. We restore relationships. We restore well-being and community. And this is applicable not just to gender. I know this is a gender presentation, but this is applicable to all areas of difference and all areas of protected classes. I want to share with you briefly my own experience with restorative practice in the workplace. And I will share again that I work for a school where reflective practice is literally part of the performance metric for our teachers. So it's an environment where people are able to have these conversations pretty easily because we teach it to our students as part of character building. But we had a facilitated session with a trained facilitator. And the question he asked of the group was, what was your first experience with race, with racism? And I was in a group with 2 people of color. And my 2 partners in my group shared their experiences with racism. I had to share, and I felt a great deal of shame that my first experience with racism was my own family's racism. I was born in El Paso, Texas, and my family was extremely racist towards the Hispanic community. And one of the things that they would do was drive over to the river where you could look across the river and you could see Juarez, and there was a shanty town, and my parents would laugh. And to them, that was very funny to see people who were very impoverished living in those conditions. And so it was very shameful for me to share with my colleagues that my family had been perpetrators of harm against other people. A less fraught example of what a restorative conversation might look like. And before I move on to that next story, I will tell you that my colleagues were very supportive and comforting, which again felt odd for me because I thought, my family was perpetrating harm. Why are you comforting me? But I also recognized that I've tried to put up so many walls and I've been estranged from my family for years and I've tried to do work as an ally, but it hurt me to talk about this experience of my parents' racism. So it's something I have to face that's a part of me. Another less fraught example is I have my colleague next door. She's African-American. She changes her hair very frequently, and it's something I admire. She can change the length, the color, the texture. It's amazing, and I think it's beautiful. And one time she came in and she had a new hairdo, and I complimented her. I told her she looked great. She was getting ready for a wedding, and she admitted she was unhappy with her hair. And so I kind of flippantly, because I knew she changed her hair frequently, I said, oh, well, you can just change it before the wedding. And I walked back in my office and I thought, oh, God, that was a stupid thing to say. I'm really embarrassed. And so I actually walked back into her office and I said, that was insensitive. And I apologize because I'm a white girl and I don't know what's involved with changing your hairdo. I don't know how hard it is to get an appointment with a stylist. I don't know the financial, investment that takes, and I don't know the time it takes. So I apologize for not thinking of that. Really, what I should have said is, I'm sorry you're unhappy with your hair and just sympathize with you. And sometimes those moments may seem to be a bit cringeworthy or embarrassing, but if we can't be honest and have honest conversations, we're not able to build genuine, real relationships. And so that's kind of the idea with restorative practices, is we have to be able to be honest about difference and the mistakes we make. So what about workplaces where it's not so receptive to holding up the mirror? You know, not every workplace is like mine. I've worked in the construction industry. I know. Changes imposed by pressure alone only work when those in authority are watching. You got to have buy-in. They're not internalized. Without pressure, people will avoid change and new ideas. People rarely seek out personal growth and reflection on their own. So the organization must commit to overcoming inertia and change with people. Combine high levels of pressure and support to engage staff in a participatory process. I worked with a DEI expert. She has worked with our school for some time and also helped me with my capstone research. And one thing she says is we are all good-ish people. It's just about finding that honesty and, again, holding up that mirror on differences. But we all know that a lot of workplaces are refusing the work and finding reason to refuse the work, especially now. Diversity, equity, inclusion, belonging, and accessibility initiatives increased from 29% in 2019 to 43% in 2021, according to Glassdoor's economic research team. Global or corporate investment in DEI surged in 2020 in response to the Me Too movement and racial unrest. And companies were making efforts to show corporate social responsibility. But those performative, shallow, and short-sighted commitments to diversity efforts quickly lost momentum as economic uncertainty grew. And of course, the pandemic hit. In 2022, 41% of benefit reviews through the third quarter indicated that diversity initiatives were part of the overall benefits package, a decrease from 43% reported in 2019. And often we know those performative, shallow efforts involve bringing on a woman of color to be the face of DEI, make her your DEI expert, but don't give her any resources. Don't give her a budget. So what's she supposed to do? When she fails in the effort because she hasn't been supported in the effort, what happens? Lay her off, blame her. It's easy to blame this one person. She failed. Women are disproportionately impacted. And Paula Bratcher-Ratcliffe, CEO of Women Impact Tech, did a report on this. She says women have a more difficult time finding jobs after being laid off. Of 1,500 tech industry professionals laid off in the fourth quarter of 2022 from the top 20 tech firms, 78% of men found new employment, while only 63% of women secured new jobs. And who was hit? HR professionals, talent acquisition professionals, recruiting professionals, and DEI leaders make up between 33 and 66% of layoffs, according to the Tech Layoff Report of 2023. We're also seeing legislative challenges. State legislation in Florida, Kansas, and Texas have challenged DEI efforts. And then we have everybody's favorite Supreme Court decision, Students for Fair Admissions, Inc. versus President and Fellows of Harvard College. The Supreme Court held that Harvard's and the University of North Carolina's admissions policies violated Title VI of the Civil Rights Act, in addition to the 14th Amendment. So being a visionary HR professional, could future challenges to workplace diversity efforts and protected classes also receive a favorable hearing by the court? And Justice Gorsuch's concurring opinion with Chief Justice Roberts' decision signals the possibility that Title VII may be required to be read to be colorblind, according to Kent Greenfield, a Boston College law professor and former Supreme Court clerk. While this particular decision deals with race as a protected class, could sex and gender come under question in the future? If it does, are we as a culture ready to lose the legal protections afforded on the basis of sex? I also just want to ask the question, why isn't the HR profession regulated? How many of you have heard the following? Let's just slot her into HR since it doesn't require any special expertise or education. How many of you have walked into a newly established HR department where the previous person who was doing HR duties, I have big quote marks that I'm making right now, they have no concept of compliance. So you're walking into just a nightmare and you got to fix everything and you got to get buy-in from leadership because it's an absolute mess and nobody understands compliance. Visionary HR professionals are seeking out programs like the Tulane MJLEL program. We're seeking out SHRM certification. We seek out certification through the HR Certification Institute, but we don't have to. So look at finance professionals who have to get their Series 6 or their Series 7 or their CPA license. What about education professionals who have to get a teaching license and get their continuing education credits? Legal professionals have to pass the bar, get their CLE. But HR professionals work intimately with the law, and we don't have to. So I just like to ask that question. What workers want? They want DEI. And DEI, hopefully I have proved through this presentation that DEI is compliance. 80% of workers believe that DEI is an important requirement when deciding to accept a new position within an organization. I think the statistics I've talked about tonight show that the pendulum is not swinging in the direction of greater inclusion. As a culture, yes, we do have to hold our workplaces accountable for all kinds of discrimination, those blatant exclusionary practices, as well as the subtle, facially neutral structural bias that has a discriminatory impact. Every business of every size needs to make compliance a top priority. DEI is compliance. Because when we wait until it's a lawsuit, it's too late. And yet we do have to hold our courts and legislators accountable. We have to hold judges accountable for having the ability to recognize not only obvious and overt discrimination, but also subtle practices of workplace exclusion, so that the courts themselves are not upholding structural bias, perpetuating that third generation of gender discrimination. And yet, how can we expect our judges and workplaces to comprehend a problem that doesn't look like a problem to the majority? When a Supreme Court justice can even fathom the concept of removing legally protected classes under Title VII, he has provided the ultimate evidence that third-generation discrimination is alive, it's thriving, as women continue to leave toxic workplaces because they lack the resources to take legal action and they miss out on advancement opportunities and accept settlements out of court. Second generation discrimination is a quiet, underdocumented problem that continues to perpetuate itself and will only worsen if lawmakers continue to erode and prohibit DEI efforts. And it's also our individual responsibility to bring restorative practices and those courageous conversations about difference into our communities. So I hope you all will think about ways that you can take those concepts of restorative practices into your communities, because it really is all of our problems. Think about book groups, the PTA, church groups, Bible study, volunteer groups, etc., because it really is all of our problem. Susan Sturm started a conversation 24 years ago that we can't afford to ignore. We can't afford to stop having this conversation. Every worker deserves access within the workplace to be engaged, to learn, and to participate in workplace success. And now we'll open it up for questions.
All right, please.